Am I being detained?
No, you're not being detained, no.
See you later then.
But you're not, you can't go through there.
You're harassing me.
I'm not harassing you.
I'm trying to walk away. Okay, I'm going to go this way instead then.
No, if you...
No, I'm going to go to the bus stop. Okay? Leave me alone. Police approach me.
Yeah.
Police come to deal with crimes, do they not?
Not necessarily, no.
What do they come to deal with? Civil matters?
Well, we're here to prevent crime.
So what crime do you suspect me of about to commit?
Not suggesting you're committing a crime at all. So.
Alright then.
Welcome to the channel. Guys, today's footage comes from Audit Ed. Make sure to check out his channel and show some support for the original content. In this episode, Ed is standing outside a university campus with a camera. That's it. No confrontation, no raised voice, just recording in a public space. Yet somehow, that alone sparks a noticeable response from officers on scene. What stands out immediately isn't what they say, it's how they say it. Instead of beginning with clear explanations, the interaction opens with a tone that suggests suspicion. Before identifying a specific issue, they treat his presence as though it's already a problem. What follows is not chaos or shouting, it's something much more revealing. Ed stays calm and methodical, asking direct questions that require direct answers. When officers reference vague concerns, he asks for specifics. When authority is implied, he asks them to clearly state it. And as the conversation stretches on, something becomes harder and harder to justify. The reason for the stop in the first place. The longer it continues, the more the burden shifts back to the officers to articulate exactly what law, if any, Karag has been broken.
You guys here for me?
Yeah, hi.
Oh, why? Can you maintain your distance there?
Can. Of course, yeah.
And also identify yourselves. Did you just switch your camera on?
Yeah.
Alright, please don't delete that. I'll be requesting a copy, alright? Also yours, please don't delete that. I'll be requesting a copy.
Of course.
Alright, can you identify yourselves, please,
Can I
officers?
ask you first, sorry, what was your first name, my friend?
I'm not at liberty to give you that. When you approach a member of the public, you identify yourself. That's your policy, so identify yourself.
Okay. So my name is Simon Tops, Police Constable 693, Simon Tops, Avon, Somerset Police.
And yours is?
My colleague.
5512, Josh Burnell.
Alright, and what crime have I committed, or do you suspect me of committing?
Okay, what are you being so hostile?
I'm not being hostile, I'm just asking you, because when police approach me,
Yeah.
police come to deal with crimes, do they not?
Not necessarily, no.
What do they come to deal with? Civil matters?
Well, we're here to prevent crime.
So what crime do you suspect me of about to commit?
Not suggesting you're committing a crime at all. So.
Alright then.
What was your first name, so I can talk to you on first name basis?
No, it's fine, I'm not going to give you that.
Okay. Are you filming at the moment?
I am indeed, for my own
Okay,
protection.
what's the purpose of you filming?
My own purpose.
Right.
They walk up to him without introducing themselves, without explaining why they're there, and without setting any clear context. Ed actually has to ask who they are, which immediately highlights how casually they inserted themselves into the situation. That alone tells you a lot about the mindset going in. When he asks the most basic and reasonable question, what offense do you suspect? They don't answer it. Instead of identifying a specific violation, they pivot to labeling him as hostile. That term gets used far too quickly in situations like this, especially when someone is simply asking officers to explain their authority. Requesting justification isn't aggression, it's not escalation. It's holding public officials to the legal standard they are required to meet before detaining or interfering with someone. If there were a legitimate, articulable suspicion of a crime, it should be easy to state it clearly and immediately. The hesitation to do so becomes part of the story itself.
Can I ask why you're here at the...
Can I ask you a question? Am I being detained?
No, you're not being detained, no.
See you later then.
But you can't go through there.
I just asked the gentleman if I could go through and he said yeah.
Chris?
Did you not just tell me the way to the bus station?
You did ask me where the bus are.
And left at the machine and all the way down?
I did say that.
Yeah.
Okay, can
Okay.
I just...
No, you can't actually.
Okay, well, whilst you're walking, I'll just make it quite
Are you
clear.
following me?
I'm not following
You're
you.
harassing me.
I'm not harassing
I'm trying
you,
to
I'm
walk
talking
away.
to you.
Okay, I'm going to go this way instead then.
No, if you...
So if you... No, I'm going to go to the bus stop. Okay? Leave me alone. Alright?
Okay, that's fine. If you make your way to the bus stop, that'd be great.
I'm not going. You're not going to follow me.
What?
Which way are you going?
Sorry?
Which way are you going?
Look, if you don't want me to follow...
I'm just asking you which way you're going.
I'm not here to call...
I'm just asking you which way you're going.
It doesn't matter which way I go, and go whichever way I like. I'm not being...
Alright, I'll wait for you to go then.
I'm not being dictated to by you.
Do you know your
where
oath?
I go. Alright?
Do you know your oath?
Yeah, I do.
Can you say it to me?
No,
I'll start you
I'm
off.
not going to say it to you.
I'll start you off.
I'm not here to justify my actions.
No,
to
you're
you.
here to uphold the law.
I am
Have I
upholding
broken it?
Not at the moment you haven't.
So leave me alone.
They tell him he's not being detained, so he does exactly what a free person is allowed to do. He starts walking away. That should have been the end of it. But the moment he exercises that freedom, the tone changes again. Now they want to know where he's headed. Now they're following behind him, creating the impression that he's free in name only. And that's where the contradiction becomes obvious. You can't declare someone free to leave while simultaneously shadowing their movement as if they're not. At that point, the interaction shifts from procedure to ego. Ed asked the officer to repeat his oath, not as a stunt, not for theatrics, but as a reminder of the standard that public officials swear to uphold. The response? Refusal. The officer states he doesn't need to justify himself, and that line says more than anything else. Law enforcement authority isn't personal authority. It's delegated power, and delegated power requires explanation when it's exercised. Policing isn't a private club where transparency is optional. Your accountability is built into the job, or at least it's supposed to be.
This isn't consensual.
That's fine.
Policing by consent, leave me alone.
Okay, off you go then.
No, I will
Have a
go.
nice day.
I will go when I'm ready.
Okay, that's
Okay,
fine.
cool.
Have a nice day.
I will. I'm actually having a lovely day.
Okay. If you could make your way to the bus station, though,
Why?
that would be great.
Why?
Okay, that's fine. I'm not here.
So why do you keep telling me what to do?
I'm not telling you what to
You
do.
are. You just said make your way to the bus station.
You
Like,
said
what
you were
right?
making your way- you
Can I
said-
just ask you, what right do you have to tell me what to do when I haven't broken the law?
Okay?
You haven't got a right to tell me what to do when I haven't broken the law. So stop trying to bully me.
I'm not trying to
Yes,
bully
you are. You're trying to
find
tell
out-
me what to
I'm
do.
trying to find out why you're walking around a university
Because
with
I'm
a camera.
I'll tell you why. Because I'm allowed to.
Okay?
Photography
But
is not a
some
crime.
of this university is private premises.
No, it's not.
It
Bro.
is,
Do you know?
okay,
Are you
that's why you're wrong.
are you familiar with Section 33 of the Criminal Justice Act 1972?
No, I'm not. No,
you're
not
not. But you should be.
Okay.
Because it's the law.
Okay.
Which says at the material time of operating, the public are allowed access, whether upon payment or not.
To where?
Anywhere that is open. This is a public space. These lines were painted by the council.
The tone drops into something quieter, but more pointed. It's no longer open confrontation, it's low-level pressure. Instructions are barked out as if authority alone automatically makes them lawful. No explanation, no foundation, just volume and posture. When that approach doesn't work, they pivot again. Now it's private premises, stated with confidence as though confidence itself settles the legal question. But repeating a claim doesn't establish it. The burden isn't on the public to disprove a vague assertion, and it's on the officer to articulate the legal basis for enforcement. Ed doesn't take the bait emotionally. He doesn't argue tone with tone, he moves straight to structure. He asks whether the officer is familiar with Section 33 of the Criminal Justice Act 1972, a provision addressing access rights in areas the public are ordinarily allowed to enter. The officer admits he isn't, and that admission is significant. When an officer attempts to enforce a boundary he can't legally define, he's not operating from knowledge. He's operating from assumption. That's a problem. Ed then points to the council road markings, indicators consistent with public highway designation. Those markings don't just appear on genuinely restricted land, they're physical evidence of public access. And once that's introduced into the conversation, the claim of private premises starts to look less like a legal conclusion and more like a convenient fallback.
Well, I think you're mistaken.
No,
Part of
I'm
this
not.
university is private property.
Can I just ask you
There
another
is
something?
public access
If I
to
was to
parts
say
of
to
the
you,
university.
if I was to say to you, I'm not going anywhere, what could you do?
Sorry?
If I was to say to you, I'm not going to leave now, what could you do?
Well, I don't intend to do anything.
You
at the moment.
couldn't do anything because I haven't broken the law. When those guys rang you and reported a crime, what you should have said to them is not breaking
They
the
have
law.
reported a crime.
What did they do?
Reported a suspicious person filming at a
suspicion-
university campus.
Is photography a crime? You're recording. You're
Well, I
recording.
don't know. How-
You guys,
How
let me
do
just
I know
you,
that you're not filming for terrorist
do you know?
purposes?
You see that on your uniform?
Yep.
That thin blue line thing.
How
That
do
is
I-
an utter disgrace.
How do I know?
You disgrace the country with that.
How do I know that you're not filming for terrorist purposes?
Sir, we go
for
on.
example?
Sir, we go on what we do know, what we do, not what we don't.
Well, not necessarily.
No,
That's a game
so-
where you're wrong. Isn't
Okay,
It?
so what reasonable suspicion do you have that I'm a terrorist,
Well,
sir?
you're filming a university campus.
So you're
with a
trying to get me
camera.
on Section 43.
No, I'm not.
So why did you mention it then?
Well, because I'm just explaining that you seem to think that I can only act when a crime's been reported. but
No. You're more than willing to come up to me and ask me.
Yeah.
If you can articulate reasonable suspicion that I may be a terrorist.
Well, you're walking around a university campus with a camera. And
This is a unit.
And you won't explain why.
Security labeling someone as suspicious doesn't magically transform lawful activity into criminal conduct. It just means someone didn't like what they were seeing. Discomfort isn't a statute. When Ed asks a straightforward question, is recording itself illegal? Notice what happens. They don't answer it, not directly, because they can't. There's no blanket prohibition on filming in a place open to the public. So instead, the conversation shifts to possibility. How do we know you're not filming for terrorist purposes? That's not an articulable suspicion based on observable facts. That's speculative escalation, jumping from a camera to the worst case scenario without anything concrete in between. Ed cuts through that immediately. Policing is supposed to operate on what you can point to, not on what you can imagine. Reasonable suspicion requires specific, objective facts. If the only behavior identified is someone holding a camera in a publicly accessible area, then you haven't articulated suspicion of a crime. You've articulated discomfort with scrutiny, and those two things are not the same.
Well, then it gives me suspicion of what your activity is.
So you think I'm a terrorist? You have reasonable suspicion that I am up to terrorist activities.
I don't know why
I'm not engaged in any
why are you
hostile
filming?
reconnaissance because I can, as my rights allow me to. Is this not a free country?
Yeah, but...
So, and am I not allowed to own a camera?
You are allowed to
You're
own a camera.
filming. What's the difference between
You're
you and
allowed
I?
to own a camera and you're allowed to film.
And what's the
And I'm
difference
not-
between you
and
and...
I'm not preventing you from doing that.
But why
I'm
are you
not
accusing me of being a
camera.
terrorist then?
I'm not accusing you of being
Well, why
a
are you saying
terrorist.
I'm suspicious?
I'm just saying there are some concerns about your
What concerns?
nature of why you're filming
What
in the
concerns?
university.
What concerns?
But then it gives me suspicion for why you're here with a camera.
Suspicion is not a crime.
No, but it gives me grounds to do certain things if I feel it necessary.
Are you threatening me?
I'm not threatening you.
So what do you mean then?
what the law is.
Well, you don't know the law because that's not
Well,
right.
I think I do.
Well, tell me what reasonable suspicion you have.
Well, why are you filming a university when it's
I'm not telling
closed
you.
with a camera?
I'm not telling you.
Okay, well then I'm suspicious.
That's fine. You can be suspicious.
I can, yeah.
Yeah, you can.
But then I can also act on that suspicion
No, you
if
can't.
I feel it appropriate.
You can. Yeah, you can, and I'll sue you.
Okay, well, but that's my decision.
Yeah, I know, and you'll lose your job.
Well, I'm not doing that, am I?
No, because you're scared
But
to.
you're not helping our cause.
I don't
here,
have
are
to
you?
help you.
Ed finds himself repeating the same point, not because it's unclear, but because they keep acting as though it hasn't already been addressed. Filming in an area open to public access is not prohibited simply because someone dislikes being on camera. Personal discomfort doesn't create legal authority. He also points out the glaring contradiction. The officers are actively recording him while suggesting that his recording is inherently suspicious. That inconsistency matters. Like, it exposes that the issue isn't the act of filming itself, it's control. It's about who holds the lens and who gets to document the encounter. Then comes the more concerning statement. My suspicions give me grounds to do certain things. That's where the legal threshold becomes critical. Suspicion, by itself, is not a blank check. It can't be vague, it can't be hypothetical, and it certainly can't be based on a general unease with being filmed. For suspicion to justify police action, it must be reasonable, grounded in specific and articulable facts, and tied to a recognizable offense. Without that connection, it's not lawful authority. It's assumption dressed up as power.
I don't have to help you, do I?
You don't have to.
No, I don't.
Okay. Well, okay. I think we understand where we are.
I know where I understand where I am. I know the
understand
law.
where I
You
am.
don't. You those gentlemen over there, the guys who called the police, whoever called the police, I suggest you go and speak to them about Section 5 of the Criminal Law Act 1967, making a false report, because that's wasting police time, which is actually a criminal offence.
Okay. It's been nice talking to you. If you're heading towards the bus stop, then
I'll go wherever I like.
Have a lovely day.
I'll go wherever
Well, you
I
won't
like.
go wherever you like.
I will indeed.
Because parts of this.
I'll go
university-
anywhere that is publicly accessible. I will go.
Yeah.
Yeah, and no one will stop me.
Yeah.
Not those guys up there. Not you guys
But what
either.
you need to understand at the moment.
I don't need to understand
just say
anything.
that
I
we're
know the
clear,
law.
Is so do I.
Yeah, no, you don't.
So do I. Okay.
You don't. You don't even
This
know
is
what
a-
Criminal
this-
Justice Section 33 of the Criminal Justice Act
This is-
1972 is. Do you know it?
This is a
You need to
private.
know the ins and outs.
Of course you know. Of course, if you're gonna uphold the law, you have to know the ins and outs of the law. How can you tell me that you don't have to know the ins and outs of the law, but then you're here to uphold it? How does that make sense?
Ed doesn't just stay on defense, he shifts the focus. If anyone may have stepped over a legal line, he suggests, it could be the person who made the exaggerated report in the first place. Section 5 of the Criminal Law Act 1967 addresses knowingly providing false information that results in wasted police time. That possibility isn't explored, it's not even entertained, and that omission is revealing. The scrutiny flows in one direction only, toward the person holding the camera, not toward the source of the allegation that triggered the response. Then come the familiar line, "You can't just go wherever you like." That statement only carries weight if it's tied to a clearly defined and lawful boundary. Restrictions aren't created by tone, they're created by law. Ed reiterates that he's standing in an area open to public access. If that claim is wrong, it should be simple to explain why. But instead of offering a legal foundation, one officer shrugs and suggests you don't need to know the ins and outs of the law. That's not a minor comment, it's an admission. Exercising authority without understanding the legal limits that define it undermine the very legitimacy of that authority. The law is an optional background knowledge in policing. It's the framework that makes the power lawful in the first place.
You're even in Somerset Constabulary, innit?
Okay.
Absolute joke.
It's been a pleasure talking to you.
I haven't enjoyed myself, actually. You've ruined my day. So go away now, please.
Parts of the university are private premises. There are public access routes.
I won't go anywhere that is private. I haven't been anywhere that's private, and I will not go anywhere that's private. As you could probably understand from the way I speak, I know exactly what I'm doing, sir. I know the laws that surround what I'm doing. I don't appreciate you accusing me of being a terrorist.
Well,
what's your number
I've
again?
not accused you of being a terrorist. I've explained.
693. You threatened
No,
me.
I
You
haven't.
said, "Oh, now I've got reason."
I've not threatened
mate,
you
listen,
at all.
the camera doesn't lie.
I've not threatened you.
The camera
What,
doesn't
you
lie.
can play your camera back.
I will. I'll be playing. I'll be playing to your superior.
I'm just explaining that if you're filming an empty university that's actually closed at the moment, to the university's actually closed. All right, to the students. It's
I'm not a
closed,
student.
It's closed to staff.
I'm not staff.
So why are you here?
I'm a member of the public, and I'm in a publicly accessible area.
Right.
That's why I'm
Okay.
here.
Well, that's fine. If you want to film
I know it's fine.
in open public spaces.
Yeah, and I'm allowed.
That's fine, but
Yeah.
you won't be filming inside buildings.
I don't want to film inside
okay?
a building.
And if you trespass in private property,
It's a civil matter. Are you telling me that you're gonna do something for a civil matter?
I will do.
Okay. Oh, so okay.
When the officer pivots to, if you trespass and start recording inside buildings, then I'll have to take action, he's reaching for a hypothetical scenario to justify present pressure. That shift matters. It moves the discussion away from what is happening and toward what might happen. Basic trespass, in its ordinary form, is a civil matter between a landowner and the individual on the property. It doesn't automatically become a police issue unless specific statutory aggravating factors apply. The mere possibility of a future civil dispute doesn't grant immediate enforcement authority. You don't get to preemptively threaten action over conduct that hasn't occurred. Ed isn't inside a restricted building, he isn't bypassing barriers, he isn't ignoring a clearly articulated, lawful direction grounded in a defined power. The officer is attempting to anchor authority to a scenario that doesn't exist in the present moment. And that's the recurring pattern here. Instead of identifying a concrete offense, the justification keeps drifting toward hypotheticals. Policing authority must be tied to actual conduct, not imagined escalation.
They asked you to leave a private premises and you
But I
refused.
haven't been on private property.
And you refused.
But I haven't
to.
been on private property.
Then I'll have
Sir,
to consider
listen.
my powers under the breach of the peace.
Oh, so now you're threatening me for a crime that listen, what part of my behaviour is threatening or abusive?
Well, nothing at the moment.
Okay, so don't threaten me with something that
I'm not
hasn't
threatening
happened
you.
or that isn't going to
I
happen.
also
You
know
are.
the
That's
law.
no. Listen, you're
Okay?
just threatening me with breach of the peace when a breach of the peace isn't going to happen
Well,
because
one
I'm
of
not
my
acting in.
fundamental roles is to prevent a breach of the peace.
Yeah, but there's going to be no breach of the peace because I'm not acting in a
That's
threatening
right.
or abusive
So
behaviour.
All I'm saying is don't go into private premises,
listen,
don't film in the
how many
buildings.
times do you want to say that?
Okay, otherwise...
How many times do you want to say that, considering the fact that I said...
And then I'll have to support them to prevent a breach of the peace, is all I'm saying.
That's fine. You
And
could
that's
do,
me knowing my law.
That's fine. You could do that, but I
I
promise
can,
you that if the course of action that you've just stated happens, I'll sue you.
Well, that's fine. You're entitled to sue
And I'm
me.
going to make a complaint. 3 complaints in this 8 minutes 46 seconds, and 3 complaints about you. You're smart for keeping your mouth shut.
Yeah, that's fine.
All right.
You can complain.
See you later then, guys. Go.
Okay.
Be gone.
Then, almost out of nowhere, breach of the peace gets floated into the conversation. Wonky, as if invoking the phrase alone adds legal gravity to the moment. But that power isn't a rhetorical safety net. It exists for very specific circumstances, where violence is occurring, imminent, or someone is genuinely at risk of harm. It's not there to patch over a weak foundation. Ed asks the only question that actually matters. What have I done that's threatening or abusive? That's the pivot point, because breach of the peace isn't about irritation. It isn't about tension. It isn't about filming. The officer's response? None at the moment. And that answer effectively collapses the argument. You cannot warn someone about breach of the peace while simultaneously conceding there is no threatening conduct. If there's no aggression, no violence, no hostile crowd, no escalating volatility, then the legal threshold simply isn't there. Invoking breach of the peace in the absence of those elements isn't preventative policing. It's attaching a serious power to a situation that doesn't meet its criteria. And when that happens, the phrase stops being a safeguard and starts sounding like leverage.
No need to be rude.
I'm not being rude.
Okay.
Plus, is rudeness a crime? Is it a free country? If I would like to be rude, I'm well within my rights to be rude. Okay? So go away, please, and leave me alone. You're harassing me.
Okay, that's fine. Thank
All
you.
right? Go away now. Told me I can't record in there, so now I'm going to have to walk round. You inform these guys that photography is not a crime as well, yeah? You educate these guys on the law. No, you're here. You're a public servant. You're here to uphold the law.
Yep.
These guys have broken the law by filing a false report.
They have.
Okay? Yes, they have. Yes, they have. They reported a crime when there wasn't a crime being committed. They made a false report. is a breach of Section 5 of the Criminal Law Act 1967, and you are failing in your job right now,
Okay.
officer,
Well,
constable.
Thanks very much. It's been very nice talking to you. If you can maintain yourself on the public places,
I'll go wherever
okay,
I like. Thank you.
You know what my position is.
I'll
in
go
relation
wherever.
to
Yeah, you made threats. You made a threat of
I've not made a
arrest. You
threat.
did. You made an illegal threat of arrest.
What stands out at the end isn't confrontation, it's retreat without acknowledgement. After all the suspicion, the probing questions, the hinted powers, and the floated legal threats. The officers gradually pivot away from Ed and back towards security, but there's no visible effort to examine the foundation of the original complaint. The person who triggered the response isn't questioned on camera. There's no clarification, no correction. No recognition that the initial framing may have been exaggerated. That absence matters. If the legal footing had been solid from the start, it wouldn't require a quiet disengagement. There's also a subtle but important shift in momentum. At the beginning, the officers set the tempo. They initiate. They question. They frame Ed as a potential issue to be managed. But by the end, that control has thinned. He hasn't been detained. He hasn't been searched. No specific offense has been articulated. No lawful boundary has been clearly defined. What remains isn't public safety being restored. It's frustration, not because of disorder or danger, but because the interaction never successfully justified itself. When Ed walks away, it's not retreat. It's disengagement from circular reasoning that never reached a lawful conclusion. If you found value in this breakdown, make sure to like the video, share it with someone who cares about accountability, and subscribe to keep these discussions in the spotlight.